How to take a company public. When taking a company public, one should first consult with a law firm that specializes in securities and initial public offerings, or IPO. To go public, you must first file with the Securities Exchange Commission, or the SEC. You cannot offer securities before registering with the SEC. Registration statements have two principal parts. Part 1 is the prospectus or selling document, and Part 2 contains additional information that the company does not have to deliver publicly to its investors. For purposes of going public, a small business is defined as having less than $25 million in revenues within their last fiscal year. An outstanding publicly traded stock of no more than $25 million, depending on the amount of capital companies want to raise, will determine which form it is best to use. Depending on the amount of capital your company needs to raise will determine which form is needed. SB1 is used to raise $10 million or less, and SB2 is utilized to raise capital of any amount. After filing the form with the SEC staff, they are going to analyze the registration to determine whether or not you're in compliance with disclosure requirements. During this time, known as the first quiet phase, company insiders as well as analysts and also any other party that's legally bound to your company will be restricted from discussing or promoting anything that has to deal with the upcoming IPO. Once the company has satisfied SEC disclosure requirements and the registration statement becomes effective, then the company can begin selling its securities. Now remember, offering publicly traded stocks should be carefully considered with a proper management and legal team, as your company must comply with federal and state laws. Any failure to comply with these federal and state securities laws may result in court proceedings as well as an injunction and possible conviction, and it may also include repayment of illegal gains in addition to civil penalties.